His Excellency, Mr. Ambassador, mentioned that the U.S. supports Moldova, and we noticed that many times the international organizations know what subjects are important for Moldova and why other countries support this sector, because they live it. They live in a society where the rule of law, the arbitration works. And this is why they decided to support Moldova in other countries, so that they also build their social contract, because this is what it means for Moldova, especially after receiving the candidate status, to end that ping pong and to follow that direction. And we either do it right, based on our experience, which it's very limited because we are a young country, or we take best practices at international level. We know that many countries build institutions, build tools, and why not? Let's try those tools. We know that the London, Paris, Stockholm, and other states' courts are much more developed. They had different cases, they identified best practices in order to prevent litigation, to apply arbitration. So why not just apply it? And I'm very happy to notice that the state finally turned its face to alternative tools. Maybe if we didn't have so many crises, we wouldn't have had this many progress, and unfortunately the crisis was the trigger that led to these progresses. And yes, let's appreciate this opportunity and let's contribute to it. And let's give the floor to Valeriu, and Valeriu will speak about the Moldovan practice. Hello everyone, my name is Valeriu. My name is Valeriu Cernei, Senior Associate in Gladei and Partners, and with the support of EBRD, in partnership with IDLO and with the USAID support, we conducted a study to understand what is happening in the Republic of Moldova, what is the current legislation and practice regarding arbitration. So, we made an assessment of the arbitration legislation and the implementation into practice. Why we wanted to do this study? Because we wanted to understand what is the status quo, because knowing what is the baseline, we can improve. And when we did this study, actually I had the great luck to be part of the team together with Mr. Koval, Mr. Gladei, and with our colleague from the London University, Mereniti. She had a great contribution regarding international best practices that we added in the study. So, we have analyzed a number of sectors. First of all, we analyzed the current legislation. We assessed the institutional framework, what is happening with the arbitration courts in Moldova, what is their practice, and how often litigation arrive into arbitration. If we have many more litigation that is solved in arbitration court, arbitration convention, what are the legal criteria, what is happening into practice with this convention, the arbitration court, which again we would like to highlight how important it is for this court to be independent and impartial. What is the procedure? What are the gaps? What is the impact and consequences of the gaps in arbitration procedure? And the main is the decision and how the arbitration court decisions are executed, are implemented into practice, and of course, what are the deficiencies and the differentiation between courts and arbitration courts. As we know, these two types of courts support each other and control each other. So let's go to and let's speak about the legal framework, general information. Actually, there's a lot of information here. When we worked on the study, we said that we had a lot of things to report on, but of course the authors and the donor asked us to, simplify the information and only include the key elements that we identified. So we identified the problems, and to the right side of the slide, we came with recommendations, not solutions, because of course we are not there yet. We can only come with some recommendations because still there, as we know, currently there is an attempt to improve, to propose a legal draft. So the first point was the so-called legal or legislation inflation, where we see repeated provisions in multiple laws and actually contradictions between different provisions. For example, law number 23 says some provisions, and then law 24 brings provisions that are exactly the opposite. And our recommendation that we formulated here was to unify these two laws, because this would be a solution that would exclude the repetitions, would exclude confusing points and contradictions. Nothing stops us to have a unique law to include everything and all the elements for arbitration, including international arbitration. This is what we have at the moment. We have two laws, and oftentimes we have the question, where do we apply the law 23 if the provisions of the law 24 don't apply, and vice versa. So in order to solve this issue, let's unify these two laws and create one law. The second problem, or the second element that we identified, is the implementation into practice, right? We said that we have the two laws, and there is, of course, a discretion of the arbitration courts to have a level of discretion or to apply derogations. And here we ask, how much can the arbitration court can apply derogation so that the procedure goes accordingly and it goes smoothly? And the next question is, does the law allow for this? And I noticed that in some situations, arbitration institutions apply the civil procedure code, because using this code, many arbitration courts can identify a solution and continue with the case. And the recommendation is to, of course, modify or clarify the unclear provisions. And as we said, another point was the application of civil procedure code. Here we know that the courts have an important role to name arbitrators, to name mediators, but there's no clear explanation how the court does this. Does the court involve the parties? So these are many questions that we could not find a reply in the current legislation. So it would be useful to have a solution for these gaps and to allow the arbitration court or the court some clear guidance so that they follow a clear procedure, which we didn't identify in the current legislation, and we would love to see it in the new amended law. Speaking about the institutional framework, we have on the webpage of the Supreme Court of Justice, we have 34 arbitration courts, and we've tried to be as objective as possible. I mean, we requested through letters, and by the way, at the end of the study, you can see the letters that we sent to all the arbitration courts from Moldova, and we asked, dear court, please let us know what is your practice in implementing these laws. What are the issues that you face in implementing the law, and what is your practice in applying the law, and what are the number of decisions, what are the number of appeals. So having this information, we would understand what is the actual practice in implementing the arbitration legislation in Moldova. And despite the fact that we sent the letters to 34, only 5 were called by us functional. By functional, we mean that they publish information regarding internal regulation, they have information regarding conditions or criteria to use this arbitration court, data contact data, and you will see that the others don't even have a real address, a verifiable address. So we sent letters to these courts and we received a reply. The named institution is no longer working at this address. So this is really odd to know that we have 34 arbitration courts, but in reality only 5 are functional. No contact data, no email, no phone number. This is very this limits the access to arbitration procedure. Let's say when the parties would like to go through arbitration, be it at the phase of signing a contract or solving a litigation, they need to know which court of arbitration is available to them. What is the regulation of that court? What are the number of decisions approved by that court? What are the appeals? And regretfully, currently we don't have access to full information. We cannot conduct an objective analysis. I would love to, as a justice seeker, let's say I want to go through an arbitration court, so I don't have full information. There are, what we noticed, a lack of contact data or unupdated contact data, the lack of decisions, numbers of appeals. We want to see what is the reaction of the courts regarding the decision of the arbitration court. Does that arbitration decision held in court or not? We want to know about this. And as a result, as a result of this exercise, we understood that only very few arbitration courts issued decisions that held in further on court additional level of justice. So the recommendation, of course, is to regulate this aspect in the new unified law, to have a regulation for functioning of such institutions, an obligation to publish the data, including statistical data, and to have a supervision authority. Of course, this has to be created, because unfortunately, if we leave these elements to the arbitration courts themselves, we see what is the reality. We don't see what is their capacity, what is their level of activity. So if we speak about the problem of how litigation can go to arbitration and balancing these types of litigation, yes, we have the Law 23, we have the Law 24. By the way, regarding the contradictions between these two laws, between the provisions, both laws mention which litigation the law covers and which litigation can go to arbitration. And we notice that there is no general rule that gives us a clear answer regarding which litigation can go to arbitration procedure. For example, there are many old laws, I think from the 1995 or maybe even earlier, says that litigation related to this law shall be solved into court. And then the question arises here, can we solve this litigation in arbitration court, or this formulation excludes this method? So we were unable to find a reply to this question. We don't know if there is a certain reply here, and I think that the task of the work group that is working on the draft law is to make an understanding. What is the general rule? Because we have the provisions of the Law 23, then we have Law 24, we have recommendation from the Supreme Court of Justice, but we don't have a total law that covers all the aspects of this issue. So we also have types of specific litigation, like insolvency, competition, legal rights, consumer rights. So we have many questions. How much are these litigation suitable for arbitration court? The rule says that we need a competent authority to analyze this case. So what is happening with these cases? Can the insolvency administrator go to arbitration? Administration sign a contract to go through arbitration? Maybe that arbitration clause brings efficiency. Does that insolvency administrator has the right to do that? So there are many details here that needs to be clarified so that the procedure is clear, because now many of these points are left on the shoulders of the courts. But the courts might not know how to solve this kind of litigation. So we need to clarify which type of litigation, which type of disputes can go to arbitration courts and which go to regular courts. For example, if we speak about private entities and competition, can private entities go to arbitration court to solve an issue related to competition, or they have to go to court? So looking at the current legislation, it might seem that the courts solve this kind of competition litigation and disputes, but from other countries they apply arbitration courts. So you will notice this in the study. So maybe we can have an opportunity here to have disputes and litigation related to competition going to arbitration. Also, we have work litigation and disputes and consumer litigation and disputes. All of these were analyzed, and we analyzed the practice in the US. And by the way, we noticed that in the past, work litigation and disputes were not allowed to go to arbitration, but the legislation changed. And now work conflicts and disputes with the consumers are now available or are possible to be taken to arbitration. But in certain conditions, for example, they need to create a deadline, a time deadline, guarantees for the consumers that decide to go through arbitration instead of going through courts. The next point I want to mention is the recommendation. Of course, we mentioned the issue, and to the right you see the recommendations. We of course recommend to have a unified approach that covers all types of specialized litigation. And now if we speak about arbitration convention, here again we identified a number of issues. For example, ensuring enforceability of the arbitration agreement. Here we have many questions. The third party, does it have a right to enforce the decision? What is the national practice? We notice a big discrepancy between national arbitration and international arbitration. The second is the content of the convention, that mean mandatory phases for a friendly resolution of the conflict prior to the arbitration. But when I speak about Law 23 versus Law 24, there is a contradiction here. We don't know when this procedure is mandatory and when is just recommended. It's not a clarity here when the two entities can go voluntary and when it's mandatory. So regretfully, in the current formulation of the legislation, we were unable to find a clarity. So of course the recommendation is to come with a unique approach in that unified law that will be formulated. Now, speaking about the arbitration court, I will not stop a lot here. I would just like to mention that it was important to mention in the maybe in the new unique law that it shouldn't be the general rule of 3 arbitrator when the desire of the parties is to have a unique arbitrator. Of course, this is according to the desire of the parties, but the current legislation states that there is a need for 3 arbitrators, which, looking at the international context, we don't think that it's absolutely mandatory. And we also notice a lack of regulation of arbitration with multiple contracts. So we don't understand the procedure there. And speaking about the immunity standards and solving the conflict of interest that can occur and that can lead to a recusal of some of the arbitrators. So we need to have clearer standards how such conflict of interest will be solved and how the recusal happens. So let's speak about the procedure. I don't have a lot of time, so of course I will speed up, but you can read the entire study. As we know, we have currently some institutions which are not regulated in the Law 23, and I speak about the accelerated procedure or the simplified arbitration procedure, and the law does not provide provisions. But in practice, we see that the arbitration courts use this kind of opportunities. So now the question is, how much can the arbitration courts go beyond Law 23 and 24? How much discretion measures do they have to extend the provisions of these 2 laws or to apply additional codes or laws? So we were unable to find a clear reply. Or, for example, introducing a third party or connecting the procedures. So we were unable to find a reply in the legislation. And not lastly, the use of IT tools. We keep speaking about digitalization in justice in the context of national courts, but we forget about the arbitration courts. I think it's an important point, and I think that arbitration courts can benefit from an additional provision in the law, or at least for an internal regulation, to provide, to offer the right to the parties to use IT tools to participate in the procedures, because this already happens in other arbitration courts. And the final point is the decision. So I would like to speak about the enforceability of the arbitration agreement. So we need to have a procedure here, a clear procedure, and our recommendation is to give a enforceability to the arbitration court decision. Yes, and if the parties don't agree, they can appeal. So we shouldn't go through courts once again, because from the experience of my colleagues, even for me, I waited for more than 1 year to wait for that title of enforceability. So we went to court, then the court had delays. So there was a lot of delay, and this meant that one of the party was delayed so much to return its goods and to have a release of goods. So the question here, do we need these titles, enforceability? So our recommendation is to, of course, regulate a standard and to clarify these procedures, and the collaboration with the courts as a measure of mutual support and as a measure of control. When we speak about issue some titles, enforcing a decision, we need to clarify how much of the civil procedure code applies. For example, We had a question here. When a decision from a foreign arbitration court comes, so can we ask for insurance? So the practice is very different. We had cases when such a request was rejected. We had cases when the courts found a logic, a provision, and they said, yes, while I analyze this arbitration court decision, there is a danger there, and we would like to ensure, to guarantee that the goods, the parties don't disappear. So there is a different practice, but we consider that there should be a detailed regulation and provision of the role of arbitration court and regular court when it comes to mutual support and supervision. I apologize for speaking so much, but I encourage all of you to read the entire study, because I assure you that we've identified many interesting things, many deficiencies when it comes to implementing into practice the current legislation. We encourage you to read it, to come with feedback proposals so that the new draft law is as healthy, as robust as possible. Thank you so much, Valeriu. You are right. It's very difficult to cover such a vast topic in 15 minutes. So, but let me remind you, please keep your presentations in only 15 minutes, because otherwise we will never go to lunch and we will have disagreements here. So you heard many times from Valeriu about the deficiencies, but that is the situation. The role of a baseline study is to identify the problematic points, the pains of the system, so that from that SWOT analysis we can transform the threats into opportunities and the risks into solutions. So it's a good moment now to do that, because we have a Ministry of Justice that is open. We reported the findings and we found an open door. Regretfully, in the past, this didn't happen, and we had very reluctant communication with the former ministries of justice, and then there was a loss there in the institutional memory. We would talk to some people, and then when we would come back with updates, those people were no longer in those positions. So we think that now is the right time to conduct these public hearings, to send proposals and ideas to improve and to create this unified law. And as far as I noticed, it was not published, the draft law, but we will keep an eye and we will share that proposal so that as many people as possible check it and contribute. Because as you know, the practice is to criticize once it is adopted, but I propose to contribute with proposals and not to criticize later. Let's change our mindset and let's contribute with proposals and follow this study. The study shows major issue, and Lena will contribute, and Ion will contribute, and Sorin will speak about their sector. So everybody will contribute today and then later on. If you didn't participate in this reference study, later of course you can contribute, because as we noticed in the past, we had two essential studies with many recommendations, but as we mentioned, it was just collecting dust. And this led to the current legislation that has these unclarities. And as we know, usually the truth is in the middle. So we should explore the practice of the Nordic countries, but maybe they are more extreme, right? And let's analyze the South practice and let's examine what can work for us. So first of all, I would like to thank for the opportunity to present my small successes, actually ideas, I would say, and I welcome
the previous speakers. I met a lot of friends in this room, and I didn't actually check the agenda. I want to say that I have participated as an in the role of in arbitration in Geneva, in Rome, in Sofia. I have approximately 11 involvement in Ukraine also. So I don't know if I can brag about my age, but I can brag about my 27 years of experience, that's for sure. So I would like to present a subject about ethical and procedural aspects in arbitration. And from the beginning, I would like to tell you that there are a lot of questions related to this. From the legal point of view, ethical point of view, about proposals, about conclusions, or is it just interaction, which is an efficient communication actually between the participants of the procedures with the third parties, but also with the court itself. I would like to disappoint you, all of you. Actually, this was a challenge which was related to something that happened, but in my experience as an arbitrator and as a lawyer that represents the interest of the parties that participate in the process, in the arbitration, and I will tell you more during my presentation, but I wanted to first tell you that I was inspired by the subject that you have chosen for the study, the presentation that was made by Mr. Serbenko also in terms of changing things in the process of selecting the representatives of the public authorities that are participating in the arbitrary procedures. And in that sense, I would like to add some gas to the fire by saying that there is also an additional problem selecting the arbitration specialists. And when Republic of Moldova is obliged to participate in such procedures, we have to speak about the integrity of those people. I have a sad experience. I applied many times, exactly like Mr. Gladei, and we were rejected from those contests organized by the Minister of Justice. And if Mr. Gladei continues to participate, I at some point decided that it's unuseful, and we stopped participating to that context because the smallest price is should be 100 lei. And if we have this price, let's see what happens. And we just add a clause that this is hard work and it's going to be paid, let's say, 500 euro. I'm not sure this would be an option. Nevertheless, I think solutions sometimes are weird. Okay, coming back to the subject. I'm not going to speak about ad hoc procedures. Why? Because those that practice them, they know that the ad hoc procedures are applicable in the context of the rules of the parties, and it would be an error for the parties that have participated in the rules of procedure creation not to follow those rules and to show not very collaborative and friendly approach, sometimes even hostile approach. I will not also speak about the arbitration procedures which were established after the convention was signed, and I'm speaking here mainly about the process of documentation. Why I'm not going to speak about that? Because it's a principle of two-party approach when the institution and the court is exchanging written communication, and this oftentimes excludes and actually brings shadow to the process per se. I will not also speak about some of the interventions that are unfriendly of the parties, but also of the arbitration. So I am aware that we live in a period of time which brings a lot of changes, a lot of challenges, a lot of religious and political impact. And in this sense, I believe that a higher level of tolerance cannot affect an arbitration procedure if all the stakeholders are aware about the consequences, about the fact that this kind of unfriendly intervention will bring only damage for the procedure, which is a beautiful procedure. What I am going to talk about. So I took it as a challenge to limit myself not to only to the legal tools, because of course arbitration specialists and the lawyers, even students learning this field, they don't have to make too much effort in order to go to the law and just read what it's in the law and read the list of legal tools. That is why I'm not going to speak about that, but I chose to speak about attitudes, behavior during the process of arbitration of all the stakeholders. I believe this to be important. Definitely, I will make some legal, I will speak also about some legal aspects, because we cannot go away from fully from the legal framework, and how to apply it in the within the professional associations or some institutions. And I'm speaking mainly about ethical rules of arbitration, because we have codes of conduct, and we definitely don't have concrete rules that would describe how, if you want to say, how clean those people should be involved in this kind of in these kind of situations, because it's about deciding the fate of a company. If, for example, a company is in insolvability, it's practically a person who decides the fate of that company. So, I mean, generally speaking. Okay, let me see. I would like to switch on my presentation. Let me see if I can get it. Okay, so general information. Shortly, I'm going to speak about the levels of interaction, which is more a technical aspect. So how the parts are interacting at different phases. At the phase when they negotiate and they sign the arbitration convention agreement. You know, in many situations, the truth is, when you sign an agreement, this kind of agreement, the parties, they don't have so much time to assess the arbitration convention itself. And they don't think so much about eventual unpleasant situations that they can face if not executing some contractual restrictions. So, I mean, this is obvious to some extent, but this is also related to the people's capacities to properly negotiate in a litigation situation. So it's about arbitration. And in essence, so it's part between the parties and the arbitration institution. And this is an exchange of communication depending on the regulation that exists. And at this phase, usually, the temperature of the relationship between the subjects, between the stakeholders, is very mild. So the process is not initiated, but it's just a communication phase where the institutions, based on their internal regulations, they make some notifications, they write some letters, and usually this is done through the board or through the secretariat. The most interesting part for me, option, is the level of interaction between the parts and the arbitrary court. So these are procedures in place. Here there are procedures in place, very clear ones, and you probably know, those that are lawyers, that there are at this phase quite hostile sometimes interactions. And here is where we have to speak about ethical aspects, because it's more like a debate. So we are going to talk merely about this. It is very important also to take into consideration the rule lex loci arbitri, which answers to many questions, because by the end of the day we need a new law, as we said, that would eliminate some deficiencies, but also bring together the two laws that exist today, 23 and 24, as it was mentioned before. And maybe it's a good thing, but it depends who you ask, of course. I think at least it's good that we initiated a live discussion about the impact of this regulation, of this law. So it's about the impact on the location in a concrete litigation case, and because it's about also judge's control. And in our case, speaking about this legis, we need all the applicable laws in the arbitration, but also complain about the legislation. And lex arbitri is actually something that coincides with the legislation of the Republic of Moldova. But it's mainly academical and not so much practical, because, you know, it's one thing how this sounds in Latin, but it's different when you apply it in practice. And the last one is the paradigm and the deontology of the arbitration. And in this context, at the level of interaction between the parties, we have the legislation that regulates the means that are right now the two laws that are completed with the international arbitrary regulations. And this applies to this stage. It's about the involvement of the parties and the effects of application of this convention. And if to speak about interaction between the parts and the arbitration institution, there are the same rules, but in terms of request and other communications,
adăugându-se convenția de arbitraj.
This is also about the errors.
Spun convenția de arbitraj în prim plan sau în prima sau
So, should we use this arbitration? This is a question. Should we use this arbitration as the first rule? Because the autonomy of the parties is determined.
manifestă prin încheierea unei convenții valabile. Și atunci nu știu ce prevederile legale sau...
And then the question is, what is more important, the legal provisions or what the parties have established?
Exact, clară și pe antevorbitorul meu a zis că este...
And the previous speaker spoke about the importance of regulating every single aspect. But my question is it possible to do this? Because by the end of the day, we have the law, and it should not be it should be accessible and not excessively complex. So by the end of the day, I hope to have a discussion and understand better to what extent we make it complex. If to speak about the procedural acts, the law is excluding the controversies, and we have viable institutions. I don't know, I know about 5, but maybe there are more. And by the way, I read some information in the study that I didn't know. Thank you for the study. And we speak about the arbitrary court. So in its essence, that is something that seems to be left in the shadow, because the parties are the one discussing the matters, and the circumstances and the proofs must be there in order to see if we admit or if we reject the request. So we have to make sure that this presence and this interaction is also ethical, because the legal part, the qualification of the arbitration is actually related to the responsibilities by the end of the day to examine the cause. I'm very sorry, as a translator, it's just impossible to translate some of the things he's saying, because he's making philosophy. Okay, back to the speech. So, we have a representative that is usually helping us in the court, that should actually make the angles more smooth. But in reality, the perception is different. And sometimes the real situation brings more prejudice to the situation if compared to the expected results. But if to speak about the representatives of the parties and their actions, it's sometimes weird, because they can choose an arbitration that corresponds to the criteria of qualification. You can read about those in the convention. In my experience, I saw very weird procedures. From my point of view, weird. I don't know, you can choose another word. But the representatives of the parties have chosen some specific criteria of selection, and the condition was, for example, that they should not be more than 40 years old. And I'm asking you, is this requirement ethical? So it should be discussed further. I mean, you smile, but, 40 years old, I was 40 years old like a long time ago. In my experience, I also encountered interesting experiences also. I'm sorry for the ladies in the room. In the court arbitration court, there was a rule that no women were allowed as specialists. And again, my question is this good for the arbitration? Is this good from the perspective of the gender equality perspective? And is this good from the from the point of view of promoting specialists, no matter who they are. So there are a lot of questions still, and in case we speak about the performance of the lawyers, the arbitration cannot choose the representative of the parties, and then everything that is characteristic for the lawyers will be transposed also within the arbitration procedures. And then again the question is, this arbitration court has enough means to re-establish the good faith and the moral, ethical approach? Because if to speak about the lawyers from the Republic of Moldova, they are already used to this within also the judges' legal debates. And, you know, sometimes they go together to drink some beer, and I'm not sure this is the correct approach if we speak about an arbitration court. Because oftentimes we speak about foreign people, and they would definitely agree with me, but that this is not an ethical approach. So definitely there are problems, but we have to focus on solutions. But the procedural code of the Republic of Moldova foresees that there are some rules that ensure some penalties, but to what extent those penalties are applied? Yes, I know that I don't have so much time, and the obligation of the court is actually to understand the situation and to intervene with not so friendly maybe clauses in order to re-establish the good faith in the system. And here you see some information about the ex-arbitrary impact, the procedural code. And I think this norm is not going to be reflected in the new legislation, because the new legislation is about covering the gaps from the previous ones, and we probably will face a weird situation when the regulation, some institution indicate directly about the complementation of the legal framework with the procedural civil aspects. I don't know if this is a good approach. We shall discuss this in an additional meeting, probably. So the representatives of the parties and the arbitration court. So if some of the actions of the court are inappropriate, there is the recusation tool, and sometimes it's not clear what are the rules based on which the principles of recusation work. At least in the Republic of Moldova, we had many issues on that, because it's the civil procedural code, and in the international practice there is no criteria for verification in this context, because it is unanimously accepted that if the parties do not trust the arbitration and his actions, then definitely that person will self-dismiss. Unfortunately, in Republic of Moldova, we have those rules only on paper. And sometimes things are not applied in practice, and it's not only in our field, and we know that. But let's speak about consequences when the representatives of the parties, they don't have a good performance themselves. So also bad consequences, and to what extent those measures that exist in place can be applied in this case. The experience shows that usually we apply the just the advertisement, and this is just a tool that is not actually making an actual change. I've seen situations when they received sanctions, but just very mild sanctions, and they received 15 times in a row the sanctions. And my question is here, okay, where is the limit? We don't have a tool that establishes where is the limit. And we don't have a tool that would establish the good faith and good intentions of the parties and of the specialists in the arbitration process. So it's definitely still a challenge that we need to discuss. And of course, we had also a situation when the representatives of different institutions, when they come to the arbitration court, they sometimes even say directly, we know that you are friends with the perpetrator. So in this case, we have to definitely bear in mind the ethical part. And oftentimes, you know, things are happening in a way that we can see this in many courts in Moldova, when at the middle of the procedure, the responsible person just dismisses the parties, and a new procedure is intended to be when there is no trust between in the arbitration. But if to speak about an efficient solution for and rapid solution for the arbitration, that's definitely the situation when solutions are to be identified in international experience, to communicate also the representatives to the parties involved in the process, and when the person is part of association of a lawyer, to communicate about the behavior which is against the principle of the international arbitration.
Sau nu urmează a fi examinate. Într-un fel sau în altul, asta răcește temperatura și face...
This inappropriate behavior or infringements of the International Arbitration Court's principles has to be analyzed. And of course, has to be verified and punished. That being said, thank you for having the patience with me, and I would love to be here and to respond to all of your questions. Yes, I didn't dare to interrupt you because I thought that your topic is very interesting, and the way you present it makes me think very much. So if now we have so many issues with arbitration, you spoke about communication style. Probably arbitration is a means or needs a more advanced talent. Attorneys at law need to have a real performance, whilst this performance can be considered as an infringement in the court. For example, let's say the judge would allow for you to, I don't know, say a more emphasized speech, then the judge would say, why are you coming with this performance? Whilst in arbitration court, of course, we hear more examples of such examples. And by the way, you will hear about the participation of artificial intelligence, which compiles the relevant text, and you no longer need to work on all of this text because you can use the relevant tools. It's not seen as an advantage anymore. And when I was invited as an expert witness, expert witness, it's something hard to imagine. It's two things. I'm an expert and also a witness, and you are given questions and you have to explain, and you don't take anybody's part, but one of the parties asks you to come as an expert witness, and the question is how you make sure that you're competent. So your report starts with the following: I am an attorney at law for so many years. This is my experience. This is my bias. This is my conflict of interest. And following this biography, you cannot make any sneaky steps. For example, I participated as a expert witness, and of course, one of the party grilled me so much that if you hide something, if you declare something which is not true, there is a high possibility of during the grilling part you are being discovered, and then you lose your reputation. You lose your reputation as expert witness, as competitive advantages, and then later nobody invites you back anymore because you have ruined your reputation. So it's important to come back to Mr. Căpățână's words. A soft law or a professional code of ethics in this sector, so that everybody is aware what are the rules, what criteria are applied, because we face such situation. For example, pre-vetting evaluation. Pre-vetting evaluation is something new in our country, and this is why they needed to clarify the principles that apply, the criteria, so that we know based on what the judges, the prosecutors are vetted, what are the legal grounds, what are the articles. So I propose to have such a code of ethics in the arbitration sector. Let's meet each other, all the professionals, let's set up a code of ethics and let's apply it. And by the way, if one of the individuals that goes through the vetting or pre-vetting evaluation and doesn't promote, is not promoted, doesn't have a positive result, that's not the end of the world. It's just an evaluation procedure. You can see what was wrong, what were the infringements, and you can easily go back and correct it. And my third comment is, if we will have a code of ethics, because this is my hope, I hope that at the national level we have a arbitration code of ethics, and not only to formulate it but to apply it, and to have some independent bodies or some independent people that will say, Mr. Căpățână, you have infringed the article such and such of the code of ethics. I respect you as a friend, but you need to go through the disciplinary commission. So to apply it. And by the way, in December, the Agency for Administrating the Justice Courts promised that we will have a higher level of digitalization, and it's going to be a live stream of the proceedings. We won't have the excuse that, oh, I was misunderstood. No, nobody will have an opportunity to be misunderstood because of the recording and live streaming of these procedures. So transparency will have a central point. So I jump from Mr. Ion to another Ion, Mr. Ion CREţU. He is a university professor. He is my colleague to the National Justice Institute. And by the way, we are now going through the evaluation procedure, it's not that I'm promoting my institution and my colleague, Mr. CREţU, but I appreciate him. He is a practitioner in insolvency. He is a lawyer. He is arbitrator in our Chișinău International Court of Commercial Arbitration. So please take the floor, Mr. CREţU, because I can speak a lot. Thank you so much, Mr. Gladei, dear members, dear participants. I see a lot of supporters of international arbitration, and I hope that the topic that I will present will be of your interest. And I will speak about a problem that it's not accidentally selected by me, but I selected it because it's often met in arbitration procedure. For example, when I was part of the procedures, I felt this effect when one of the parties wanted to launch the arbitration, and that being said, I will show 5 questions, and at every question or issue I will try to propose a solution, or at least to formulate some sort of a roadmap. So the first question that comes to mind from the practice is if the impact of the insolvency procedure can be on the arbitration procedure. So we have here the Article 3 of the Law 23 regarding arbitration, which says that any patrimonial right can be the object of an arbitration agreement. So this means that litigation related to insolvency are not excluded from the arbitration procedure. So it could lead to an arbitration agreement. Point 2 of the same article mentions some exceptions. So arising from lease contracts, patrimonial rights regarding housing. So it sounds like there is an exhaustive list of issues mentioned in point 2 that are clear. So this is one hand. The law on arbitration, to make a conclusion, does not exclude litigation related to insolvency, and insolvency can go through arbitration procedure. But on the other hand, we have Article 5 of the law for insolvency, which mentions 2 important things. Article 1 says that the application for the initiation of the insolvency process is examined only by the insolvency court of justice, which covers that case. So, in accordance with the jurisdiction. So we see here their competence, and point 2 shows another idea. The first point speaks about the initiation request to launch the insolvency process, and the point 2 speaks about the insolvency court, which has exclusive jurisdiction to adjudicate within the insolvency process, includes disputes related to debts. So if we put the insolvency law and arbitration law in a balancing exercise, we see that for litigation for insolvency, we have the insolvency court and not arbitration court. That is the conclusion that we arrived to. So, at first glance, things might be clear. There are no special issues related to implementation, but the practice actually showed us many issues. We found some key elements that will happen in the justice courts of law and in arbitration courts. I have an example here. So there was the decision of the International Court of Arbitration from the Public Association. We will not name it. So it was initiated an insolvency procedure, and the Court of Arbitration spoke about the early termination of a rental contract. Also, the Court of Arbitration spoke about the nullity of an order issued by the authorized administrator. It was an order that would remove some goods, and it also speaks about the availability of the rental contract. So the Court of Arbitration issued a decision outside of the law. These points had to be solved by insolvency court and not by Court of Arbitration. And this decision was declared nullified later. And another example that we found in another decision, an Court of a court of arbitration suspended so the conclusion of the International Court of Arbitration said that a notification is suspended and the authorized administrator of the insolvency procedure, it is forbidden of that person to take the goods of the party. This is pretty serious, and this is pretty, from the legal point of view, this should not happen in our practice, in arbitration practice. But let's not think that these problems are only identified in arbitration court. No, I can show you another case, another study case from the Court of Justice. So we have a conclusion of the CREștiu Court of Appeal, which says that given the fact that at the conclusion of the contract, the parties constitute the arbitration clause, the settlement of litigation and disputes being submitted to the jurisdiction of the International Court of Arbitration, the defendant raised objections against the settlement of the dispute in court in accordance with the provision of the Article 267, letter E. And the court ordered the removal of the case and to be sent to arbitration. So, for unknown reasons, the CREștiu Court of Appeal mentioned Article 267 of the Civil Procedure Code, said that this case has to go to the arbitration, and then the Supreme Court seized this case. And this kind of a solution is not feasible. We can't send all the cases to the to the Supreme Court of Justice. So if we look at the balance, let's take a arbitration court and let's take a insolvency court. We see that arbitration court cannot operate in place of the insolvency court. So we have to clarify, when the insolvency procedure starts, the arbitration procedure still applies. It's not nullified. The arbitration convention is still valid, but when the law gives an exclusive competence of insolvency court, arbitration doesn't apply. So temporary arbitration court doesn't produce legal decisions during the insolvency procedure. Another question that I have for you, for which I looked for solutions, I speak about the situation or the question, can the creditor file an initial request for launching the insolvency proceedings against a debtor if there is a convention arbitration concluded between the parties? So on one hand, we have an arbitration convention, we have an arbitration law, and if there are any litigation regarding the contract execution or what happens in practice more is the returnal of a debt. So according to the arbitration agreement, any litigation would go to arbitration. But on the other hand, the creditor doesn't want to go to arbitration, but goes to insolvency court. And then the question here, the court can reject the initial request, saying that it's not according to the competency of the insolvency court. So let me show you the Article 18 of insolvency law, which says that the creditor can file an initial request if it has a legitimate interest in filing the insolvency procedure, and second, if that creditor can argue its claims and has legal grounds for filing the insolvency process. So this situation is a pretty unusual. So if the creditor doesn't apply on time with a initial or introductory request, and if he will go to arbitration, then when by the time there is is an arbitration decision, it will be too late. The debtor will have such low resources that will not be able to pay back that debt. So there is a balancing exercise, and my opinion is, I don't know if I should impose my opinion to everyone. My opinion is that if there is a arbitration agreement, the creditor can launch the arbitration, and when there is a legitimate interest in the filing of the insolvency process, the same creditor can also launch an introductory request. So it's the desire of the creditor, be it to go to arbitration or to launch the insolvency process through the insolvency court. So I found many court decisions, and I highlight one on the screen. A part of the Supreme Court of Justice decision, and the Supreme Court of Justice says, the appellant's argument, according to which the civil society contract in point 2 grants power to the International Arbitration Chamber of Commerce from Zurich to resolve the litigation situation resulting from the execution of the contract, does not apply on this case. However, the object of the litigation cannot pay. He is in bankruptcy. So the competencies goes to insolvency court, and the Chișinău Court of Appeal has power to examine the request in relation to the object of the action. What happens in the insolvency court? I have another question for you. If the initiation of insolvability procedure regarding a debtor has an impact on an open arbitration case. So, me as a arbitrator, as a part of a team, because we were 3 arbitrators, there was launched a arbitration procedure, and then while we were going through the procedure, we heard that the debtor had a insolvency procedure launched. So here the question, do we continue the arbitration case or not? And the solution is provided by Article 79 of insolvency law, which says cases regarding the goods of the debtor's estate in which the debtor is the defendant and the plaintiff is an unsecured creditor, and which the case is pending. So the procedure is suspended until resumed by the unsecured creditor or until the termination of the insolvency procedure. So let me backpedal a little bit. We have a very beautiful rule, and I don't know how much it applies here related to procedure, but I think that this rule must be known by any attorney when in the legislation there is a referral to a judge or to a court, then that decision can be applied to other competent jurisdiction bodies. And when the civil procedure code is referred, then that referral or that point applies to other competent authorities. So let me come back to 79 article. So this article speaks about the common law courts. We don't see anything in this article regarding arbitration, but we can say that if there is an open case against the debtor, then the arbitration court has to suspend the case and its procedure. So there is a problem here. The Austrian legislation mentioned that this procedure is done automatically. whilst in Article 79 we don't see how this is happening. This suspension needs either a decision of a judge or a decision of an arbitration court. So we have to clarify this in our legislation. Another question for you regarding this provision, you see that it's very broad, and I'm speaking about the goods from the debtor's estate. So let's clarify what does it entail. Let's look at the definition from law on insolvency. When we speak about these goods, we speak about the goods that the debtors had when the insolvency procedure was started, and also the goods that could be reclaimed or regained after the procedure. So we speak about all the litigation and all the goods, all the litigation that can be pending, and they can result in obtaining of goods. So looking back at this Article 79, it's a very, very complex article, and it's also very important. And Article 79 says that the case is suspended until when the unsecured creditor is resumed its situation, or until the termination of the insolvency procedure. So we see that all the results are part of the joint procedure, and usually the debtors have to follow the insolvency law, and then only after that we can continue the arbitration. If the debt was sent for validation, it was added to the table of debts and goods, and if that debt was validated by the insolvency court, the validation of the debt according to Article 143 from insolvency law can be the subject of a definite decision of a judge of court. So if the creditor sent a debt, the debt or the case was validated, he has a decision of a court. Next, the Article 265 from the Civil Procedure Code says that in this situation, or this situation can be a ground for ending a case, because there is a decision, and this ends the arbitration as well. Another situation when the insolvency court says that this debt or this case is not validated, and it's not added to the table of debts and cases. So this means that the claim is unjustified, and here again we need to have the decision of the judge, and this can be a reason to end the arbitration. And a third case that happens a lot, and this is based on insolvency law, which says that when the insolvency court notices a legal litigation, the insolvency court can remove the debtor and can explain that the debtor has the right to go to the court of justice, or like a regular court, and we have to open here the brackets. If there's an arbitration agreement, the debtor can go to the debtor or the creditor can go to arbitration, or if there's no such arbitration clause, then they just go to court, regular court. And this applies to it. So if the arbitration procedure was suspended according to Article 79.4 of law for insolvency, and if the insolvency court noticed a lawful litigation, then the creditor has to come back to arbitration, has to ask for reinstating the arbitration procedure, and to wait for a decision of approval of that debt, and how big is the debt or how big is the case. So this would be the elements if there is a current pending arbitration case, and a insolvency procedure which is launched against a debtor. Another problem that I would like to ask is the insolvency procedure, if it has a impact. So let me read how I formulated the question. Does the initiation of insolvency proceedings against the creditor has an impact on the pending arbitration case? So according to the legislation, we don't have a provision that requests a ground for suspending these proceedings, and the Article 17 says that the cases regarding assets can continue. So the insolvency procedure can be taken over by the administrator. But here we have some issues. In insolvency law, we have the following article. The administrator can request to eliminate the fraudulent documents, which again, it's part of the competence of insolvency court. And here again, we ignore the arbitration agreement agreed by the parties in the contract. And again, in insolvency procedure, the administrator could submit requests to claim the debt or to claim the receivable of the debt. And Article 5 from insolvency law says that the insolvency court has the competences here. So I would like to mention another problem, but I see that my time is all very close to expired. So instead of rushing through it, I would like to leave it for another conference. And let me go to the conclusions of my presentation. So currently, we have to say very clearly, when the contract has an arbitration agreement and a clear arbitration agreement and an insolvency clause, there is an issue here, and this leads to infringement of the rights that the parties wanted to have when they closed the contract. In many cases, the arbitration clause is seen as an essential clause, but we know that the Civil Procedure Code says that the essential conditions are only those that are agreed by the parties. So if we apply the current provisions, it affects very much the application of the arbitration agreement, which infringes on the desire of the parties because they signed the contract where they added the arbitration clause. So this can lead to many cases of unconstitutionality, and because many times in insolvency procedures, parties say that don't start arbitration because it's not constitutionally. So we need to have a clarity here, because there is a issue, and we need to have a balance between the provisions of the contract and the arbitration convention. So this is my vision. There are some competences of the insolvency court. For example, the initiation of the insolvency procedure, designating the administrator or the liquidator, confirming the action plan, or confirming the procedure that will conduct the insolvency procedure. So this is strictly about the insolvency, but there are other things like annulling different legal acts, or satisfying litigation for not following the contract. In the case of this litigation, we don't need the insolvency procedure. We can go to arbitration procedure, and it's possible to solve it. We have the German legislation, which gives us an idea, and if it says that if the contract has an arbitration clause, and if there's an insolvency procedure against the debtor, the court can validate provisionally the creditor, and to give an opportunity to the parties to solve that litigation in arbitration, and then later, based on the arbitration court decision, to go through the insolvency procedure. procedure. So this ensures a balance between arbitration agreement and insolvency procedure. This is all in the allocated time. Thank you for your attention.
Aveți o întrebare, Victor, putem să o scoatem?
Thank you, Ioan. Do you have a question? You wanted to ask a question? I think you already answered. It was about the litigation with the insolvency, in the insolvency case, if the arbitration case is applicable. This was the question. I think the answer was given. And definitely you have to have an answer to understand what you do next, because in this case it's inefficient, because somehow you have a tool but you cannot use it. So then the question is, okay, and then what's the balance? Where is the balance here? If the modernized civil code is using the concept of reasonable, there is a trend to use this word, reasonable. And I believe we have to understand what is soft law and soft regulation in that sense. We do not have, by the end of the day, to interfere too much into the parties' activities. And in this sense, the reasonable character, when it's at the border in the insolvability cases, it's a very sensitive line. Because you can have a great clause, but the debtor can just escape to insolvability. And insolvability is used quite often today as a tool to actually scare the creditors. I remember I used to work at the bank, and a person that had many debts, at some point I met him in a park, and he was so relaxed, and I asked what happened. And he said, I was running over the banks, but now I'm in insolvability, and I'm relaxed because they are running after me. So, yes, that's definitely the situation when we have to see where is the balance. Okay, we are only men in the first panel, but in the next panel we will definitely have ladies here. So if you consider that we are not gender equal, you will see what happens in panel number 2. Okay, Ioan, it was very interesting to listen to you. And I think there was one more question for Mr. Căpățân. Let's see it in the chat. Who asked that if we can apply the existing mechanism, the international IBA guidelines. Are they applicable in our case? So, or can we elaborate something like that? Let's give Caesar what Caesar deserves. Mr. Căpățân, you were talking about Geneva, Rome, and now we go to Geneva, Frankfurt, because he also had an experience there. It's in energy field. Okay, good afternoon. I will speak in a short. Can we please place the slides on the screen? I'm going to speak about energy, arbitration in energy field.
Investițional. Vorbind despre arbitrajul comercial energetic, părțile implicate, de obicei, sunt producătorul resurselor energetice, transportatorul, operatorul de depozite sau de terminale, distribuitorul, traderul și furnizorul. Dar, în practică, totuși, cel mai deseori apar dispute între traderi, furnizori și producători. Conform unui studiu realizat în anul 2022 de către Universitatea Queen Mary din Londra și firma Pinsent Masons, factorii sau cel mai important factor al disputelor energetice a fost volatilitatea prețurilor produselor energetice. Prin urmare, în minutele ce urmează, voi vorbi câte ceva despre produsele, volatilitatea cărora dau naștere la dispute. O prima categorie de dispute sunt produsele petroliere și gazul natural lichefiat. Gazul natural lichefiat este un produs popular, din ce în ce mai popular în ultimii ani și permit producătorilor să transporte acest produs practic în orice colț al lumii, unde sunt construite terminale și echipamente speciale în acest sens. În mare parte, obiectul disputelor sunt asemănătoare ca și obiectul disputelor din contractele de vânzare, cumpărare sau de livrare de mărfuri și în mare parte țin de aspecte de hardship, forță majoră, incapacitatea livrării, surplusul sau livrări insuficiente și alte obiecte, dar cel mai des întâlnit este prețul și modalitatea de revizuire a prețului. Asta deoarece deseori contractele în domeniul energetic și în particular în domeniul furnizării sau livrării a gazelor naturale sunt de lungă durată. Ele sunt încheiate pe perioade de 15-20 de ani și în aceste contracte părțile includ expres posibilitatea revizuirii prețului contractual în cazul în care sunt careva evenimente care dau naștere temerilor de revizuire. În general, aceste temeiuri ar fi o schimbare semnificativă pe piața cumpărătorului. Un al doilea criteriu ar fi schimbarea a fost în afara controlului părții care a solicitat revizuirea și schimbarea trebuie să aibă un efect direct asupra valorii produsului pe piața cumpărătorului. Dacă nu sunt întrunite aceste trei criterii, arbitrii, în cazul în care va ajunge în arbitrajul astfel de cerere, va respinge pe fond cererea părții solicitante. De obicei, clauzele care prevăd revizuirea prețului sunt generale și în disputele ce țin de gas price arbitration durează ani, părțile depun memorii pe sute de pagini și sunt implicați diferiți experți economici, financiari, cât și firme care fac statistici în anumite piețe, pe anumite piețe. Ce țin de aspecte procesuale, având în vedere că aceste contracte sunt de lungă durată, se poate întâmpla ca pe parcursul vieții unui contract să apară mai multe dispute succesive cu privire la interpretarea uneia și aceeași clauze, da? Clauza de revizuire a prețului. Prin urmare, în practica arbitrală apare problema și întrebarea în ce măsură hotărârea arbitrală din primul tribunal are puterea lucrului judecat sau poate să afecteze hotărârile arbitrale ulterioare. Răspunsul la această întrebare deseori se găsește în legea aplicabilă arbitrajului, da, și nu în legea aplicabilă contractului, cum se confundă deseori. O categorie relativ nouă de contracte pe piața energetică sunt contractele FET în domeniul furnizării gazelor naturale și energiei electrice. Aceste contracte, deci sunt trei documente separate fizic, dar care juridic constituie o totalitate. Este vorba despre General Agreement, care este un contract, un framework. Este un election sheet unde părțile își stabilesc propriile clauze și propriile detalii cu privire la tranzacția de vânzare-cumpărare. Acest document include o clauză arbitrală și EFET, organizația European Federation of Energy Traders, propune două opțiuni pentru părți, fie clauza arbitrală privind arbitrajul la Curtea Londoneză de Arbitraj sau clauza arbitrală privind arbitrajul la Institutul German de Arbitraj. Părțile la aceste contracte aleg una din opțiuni. Și un al treilea document ar fi confirmar un individual contract care de fapt este încheiat de părți la fiecare tranzacție. Pe parcursul sau vieții unui contract, părțile pot încheia sute, dar poate chiar mii de confirmări individuale și în mod teoretic, dar și practic, pot apărea dispute care ies din fiecare confirmare în parte și toate cad sub umbrela Convenției de Arbitraj, incluse în election sheet. În aceste circunstanțe apare riscul unor dispute paralele și concomitente și părțile se pot afla în situația în care să financeze și să fie implicate în multe, de fapt, litigii în legătură cu fiecare confirmare în parte. Ambele sau regulile ambelor instituții, atât a Curții Londoneze de Arbitraj, cât și a Institutului German de Arbitraj, prevede posibilitatea consolidării procedurilor arbitrale. Prin urmare, părțile au fie continue
So the parties continue parallel processes, but it's a very costly option and it's not reasonable to use it. Or they ask for the institution the consolidation of the procedures in order for one court to examine all the processes for each case separately, each trials. In the second part, I'm going to speak specifically about the investment arbitration in the energy field. So usually this is about investment treaties, and they are usually made between countries, where the countries promise to each other the offer of some guarantees to protect the investors that are coming to the other country. The Republic of Moldova is part of 42 bilateral treaties, and one relevant and the relevant one in our case is the treaty which defines what is investment, and this is about an asset that is controlled by the investor, and there is also a process of indirect control of the goods. The treaty also makes the difference between the entities or which are called nationals, or people that have residence, permanent residence in the contracted country. So they make a difference between the nationality and the citizenship. And if to speak about legal entities, the legal entities that are acting according to the law of the contracted country. The treaty includes usually protection guarantees, and most often clauses are about justice and equity, which is the largest concept, and the interpretation can be different depending on the circumstances, but it also covers against the risk of expropriation, illicit expropriation. The Republic of Moldova was involved in 3 arbitration cases in the energy field, Energo Alliance. It was a win for the companies, but one case is still pending. One case is in the Court of European Court of Justice, so it's quite a long process. But we also have investors who have initiated arbitration cases against third countries. ALC, for example, against Kazakhstan, where the complainant part gain the cost. A few aspects related to the importance of the promotion of investments in renewable energy. In the Republic of Moldova, like in many other countries, there are support schemes through which the producers, which are eligible based on some criteria, can sell their electricity at a fixed tariff established by the regulator. As follows: before the investment happens and before obtaining the status of eligible producer, the investors have the expectation that in a certain period of time the investments will be recovered from the fixed tariff. And in this context, the modification of the legislation in favor of the in defavor of the investor would actually diminish the chances for those investors to want to come, because it's about having a guarantee ensured by the regulatory framework. And in this situation, I would like to give you two examples of two countries with big economies that in the last years were involved in many arbitration processes in values of billions of euro. In 2007, a regulatory system was put in place, a very attractive one in the renewable field. The states granted for 25 years the fixed tariffs for that electricity, and then in 2011, because of technical reasons and imbalance in distribution system, the states decided to modify that. At some point, they modified those provisions radically. And in this sense, all the investors had to face the challenge of not having anymore those initial guarantees. And of course, this affected the whole process. The arbitration courts that took those causes on board had two approaches. First approach is that the country has a sovereign right to change the regulations, and they don't have the obligation to freeze for 25 years some guarantees offered to the foreign investors. Other courts actually had a different approach. They supported the investors, saying that the investors came only because they had those guarantees. So that's how the legislation had to be adjusted, because it's about the expectation of the people that come with the money, and they want always a guarantee. So, of course, the investment in this case suffers. In the Republic of Moldova, and this is the good part, there is no risk for such disputes, just because the capacity of production is limited through the government decision 401. And the investments, taking into account this limited capacity, are relatively small in this field. But if the state reconsiders the state policy and believes that we want to have long-term guarantees, the recommendations here would be to be prudent about what are really the guarantees of the state and in what conditions those guarantees might change. The Energy Charter Treaty is a treaty that was criticized in the among the expertise. Many countries decided not to get out of that treaty. Republic of Moldova, it's still a part of that treaty. That is why we are obliged to respect it. I am sorry for taking so much time. I think I have to stop here. Thank you, Sorin, very much. It's very interesting to hear about specific fields. And the exchange of experience, it's very interesting because we depend on energy sources. This is vital. And I remember when we participated in a procedure of forced execution of the arbitration decision, which was decided by the court from Stockholm, Gazprom versus Avtogaz. That was the case, and we learned a few lessons in that situation. And in these litigations, there is a question about the intervention of the private sector. Because in the case of the Russians, they were very angry. They said that it was done in the interest of Ukrainians and in not in our favor, and we understand why that happened. And of course, that was a very loud case. But the specialist explained that why things happened like they happened, and by the end of the day, the arbitration journal specialist, they cannot take decisions without having some very concrete clauses that they base on their decision. So, you know, in the energy field, you, by the end of the day, you took something, you have to pay for it. It doesn't matter what you did with it. So, in this sense, if you take some money from the bank, you have to pay a commitment fee. It doesn't matter afterwards what you do with this. But the legislation of describing the competition, which actually the Ukrainians brought up into the discussion, they said that maybe this is they actually allocated 2 billion, and they received that money because the Russians didn't actually transport it, the gas, although they prepared the pipes. But we also have a similar clause, and Gazprom nevertheless was obliged to pay 4.6 billions. And of course, in this case, there are a lot of collateral questions about the situation, because it's one case when the politics involves, and the second thing is, for example, Gazprom doesn't have assets in Moldova, and in this case, how to punish someone if they don't have assets in that country? So, you know, it's very important to think not only about a punishment, establishing a punishment, but also about how do you apply and practice that punishment. Because if they have some real estate, yes, okay, but if they don't, and one more conclusion is that, for example, in case of the war, they cannot find an agreement. But in the case of arbitration, because they had good facilitators, they actually came to an agreement. Okay, I think now it's time to close our first panel, but let me just make a conclusion. The role of alternative solution is mainly the role of conciliation, it's mediation, it's more like a prevention tool. So it's like an amiable composer, how we say in French. So it should be a wise man there who should tell them, yes, you are right, you are also right, but let's find a compromise somewhere in the middle. And what Mr. Capățână was saying, yes, you have to have the appropriate behavior, because you can win, but 100%, but you can win also by getting 0%. And it's a difficult thing to understand, but it is viable. But you know, it's a paradox, but nobody won a case, and only the judges used to cancel something or to gain something, and it was like a ping pong game. And you know, in pre-vetting we discussed a lot about this. Andrei, remember we had a lot of situations when we had to delay some payments of the credits, for example. Okay, I don't know if there are any questions for Sorin. Mr. Capățână, I think you didn't answer. Do you remember what the question was? Do we do that before the break? Yes, can you repeat the question, please? I cannot see. Okay, can we apply the existing mechanism of software like EBR guidelines in Moldova? And are they, can they be applied in our case? It's a question that cannot be answered with one single answer. The first answer that comes into my mind is yes. Why? Because it's determined procedure. But from the other side, there is a connection, legal connection with lex ce arbitri, this law. And in this case, I can only recommend this, because it depends a lot on the intelligence of the arbitration. And if the parties are prepared to choose those kind of qualified arbitration representatives, I think the good practice shows that this is a strong yes. Because again, it comes to the professionals. And also we talked about good collaboration in the court. In general, those that work in this field, they know that there is a very creative, it is a very creative activity. Let's just use our imagination. Let's imagine a situation, actually a situation that happened to me. Actually, not to me, but in my presence. Imagine one of the representatives of the parties declares, "Dear arbitration, please let my opponent excel in his stupidity." Okay, let me see how this would influence the facilitation process. And I'm telling you that this discussion is at the limit of the code of conduct. And the lawyers know what I'm talking about. And this is a mild declaration. But in our Balkanic, Carpatic mentality, we sometimes enter into a visible duel, fighting with each other, making strong declaration, making sometimes even like a theater play, like actors, you know. So what should be the attitude of arbitration? So each lawyer builds its own strategy. So it's about different institutions and their approach. Unfortunately, what happens in the society is something we cannot filter only for arbitration or for lawyers, because they are not, you know, what we say in Moldova, they are not the door of a church. They also have sins. And so it's about the efficiency of the procedures. It's complicated. It's really complicated. Thank you very much. We created the flow of discussion.
Okay,
Vlad, I would like to give you the floor because I want to hear your opinion, because I know that you participate in such events. I know that you might have opinions, and your colleagues from the audience. If you find yourself in such examples that were mentioned, arbitration procedures, insolvency procedures, whilst arbitration is pending. So what is your opinion? Should the state pay more for representation? Should the state pay more attention in preparing the arbitrators, making them competent? Because when you go to arbitration, you can also require the recuperation of costs that were spent. So I hear many times that the Romanian state lost and that the state was imposed to pay the costs. I heard, for example, 300 million that the Romanian state had to pay after a decision of the Stockholm court. So why not to pay attention? Oh, it's complicated because of the political state. Yes, that is another element. And probably Mr. Stati can share how it looks like to bring, to enforce such a decision. And this is a very important, interesting topic. And by the way, we will send a message to Ministry of Justice through Mr. Serbenko. I think we should remove the traditional pathway. Let's jump into other pathways. Let's not only allocate the lowest price, but from my experience, I noticed that it's always the reply, the state doesn't have